Here's a pretty simple question. Should it be regulated just like any other investment? You bet your life it should be, especially when you see multi-billion-dollar collapses like that of FTX in the US.
An Australian company just won a groundbreaking lawsuit over misappropriated cryptocurrency. The Victorian Supreme Court had to determine if blockchain assets are legally protected. The ruling completely changes how judiciary views about crypto, and it could impact digital ownership worldwide. Imagine waking up to find out your Bitcoin isn't just secret money or digital wallet. It's officially recognized as property you can earn, just like your car or house, or can be subject to law enforcement. In this video, we will look into an Australian court case that had historic impact on expanding or redefining the meaning of property, which may influence your transaction of cryptocurrency. The case is called Blockchain Tech Pty Limited 2024 VSC 690. Before this ruling, Bitcoin and other cryptocurrency existed in a weird legal gray zone. If someone stole your crypto, the courts weren't even sure if they could help you to get it back because they might not treat that as loss of property. Some even formed the view that Bitcoin is electronic information or digital data, and you cannot sue somebody for loss of information. The court in this case found that Bitcoin meets 4 criteria that define property. That is, it is definable, it is identifiable by third parties, capable of being assumed by third parties, and has permanence. This is likely saying a digital photograph can be copyrighted. It gives legal weight to something that exists in the digital realm. What makes this ruling particularly interesting is the timing. When the trial happened, Bitcoin's price was about 100,000, 10 times what it was worth when the parties first contributed to the company. Yet the court valued the misappropriated Bitcoin at the transaction date price. This somehow limits the recoverable value to an amount that might be even lower than the parties' legal costs. That's like winning the lottery but only receiving the initial ticket price. So why there is a big shift towards cryptocurrency's legal classification in court? What's the logic behind this case, and how it would affect your digital assets? Let's start with looking at the facts of this case. So the judgment is about 220 pages long, involving 17 parties. But I will summarize that in 3 sentences. In short, a company named Blockchain Tech and its main shareholders sued its former secretary and her husband to recover 50 bitcoins. That was believed to belong to the company. And that 51 bitcoins included 36 bitcoins the former secretary previously lent to the company and additional 25 bitcoins that the company proposed to sell to cover its operational expenditures. So that's the short story. And here are the detailed facts. Mr. Chen and Ms. Zhao used to work together in a blockchain company back in 2015. Mr. Chen was a software developer, so let's call him the IT guy. And Ms. Zhao was an accountant, so let's call her the accountant just for convenience. For some reasons, the blockchain company they used to work paid employees entitlements or settlement lump sum by Bitcoin. So both of them had considerable amount of Bitcoins after their employment. Seeing cryptocurrency had enormous potential in crowdfunding sector and could bring exciting investment opportunities, the 2 individuals decided to incorporate a joint venture of equal shares, namely Galaxy Crowdfunding. The business didn't go well, and it did not operate the equity crowdfunding business as expected, and it incurred lots of costs. And when the regulator ASIC cancelled its financial services license in 2023, it wasn't able to provide financial services. So they later decided to launch another project in 2018 under the name of Blockchain Tech. Blockchain Tech focused on cryptocurrency exchange business and making money by crypto arbitrage. Crypto arbitrage refers to the methodology of selling and purchasing Bitcoin simultaneously, whereby making profits in cash by exploring imbalance in the price. Simply put, the IT guy attracted people to buy Bitcoins through his developed platform. In that transaction, he's the seller of the Bitcoins, but instead of keeping that cash at hand, he would simultaneously buy Bitcoins from other platforms. Since Bitcoin prices fluctuate a lot, and there is a time gap of money clearance, the IT guy will not wait till the platform receives the cash. Rather, he would deploy the existing cash to buy Bitcoins from other platforms instantly. Since different platforms charge different fees, by doing this frequently, he would be able to make a tiny percentage of profits and snowball it if the platform is big enough or the transaction volumes are high. The goal here is to buy low and sell high. By hedging the risks, traders can earn a relatively low-risk profit. Because the company operates cryptocurrency exchange and uses arbitrage methodology, it naturally requires Bitcoin liquidity to operate its business. The parties then each agreed to pool some resources together by way of Bitcoins. The accountant agreed to contribute some 66 Bitcoins, while the IT guy agreed to contribute some 200 Bitcoins. The idea here is by contributing a proportionate amount of Bitcoins, they would have this kind of 70-30 split joint venture. Pause here, you might be curious. How did they contribute Bitcoins? Well, according to IT Guy's evidence, he used hardware wallet that looked like a USB stick to store private key of the address of Bitcoin. He came into the office, showed his USB stick to the accountant and said, "Here, I have my contributions to the company." He then asked the accountant to send her Bitcoins into the same wallet. But the problem is that by doing this, only the IT guy would have access to that wallet. How would you tell if he truly made that contribution to the company or not? So over years, the accountant became more and more concerned over this kind of dealings and lack of transparency, which subsequently led towards her conduct of misappropriation. The parties have different understanding over their prospective contributions. The IT guy argued that the accountant's 66 Bitcoins were provided as a capital contribution towards the joint venture's business. The accountant argued that it was considered as a loan to the IT guy personally for arbitrage activities, and it would be repayable upon demand. The judge leaned towards the IT guy's story, but noted that those Bitcoin contributions were not capital investment, but were individual loans to the company. Anyway, that project doesn't go well either, and arbitrage strategy didn't work out. Although all of the company's trading was done through blockchain, they still had to pay their rent, wages, and cover overheads. So if they could not make profits in cash, they had to sell their Bitcoins to maintain the cash flow. At that point, feeling it was like a sinking ship, the accountant would like to get her 36 Bitcoins back. Naturally, the IT guy wouldn't give her back if she didn't have a good excuse. So in mid-2019, the accountant told the IT guy that she needed the Bitcoins because her superannuation fund was subject to an audit. And she needed to borrow Bitcoins back to verify that she had assets in her superannuation fund. That's a very odd excuse, but the IT guy believed this and transferred 36 Bitcoins back to the accountant. Apparently, after receipt of those Bitcoins, the accountant never returned them. Rather, she transferred some Bitcoins to her husband and other people's accounts. In addition to that 36 Bitcoins, the IT guy also transferred another 25 Bitcoins to the accountant. Those Bitcoins were supposed to be sold by the accountant to cover the company's operational expenses after security emergency. The accountant kept most of the Bitcoins for herself, and her explanation was that she believed there were profits made through the company's arbitrage activities, and they were her profits to keep. Let's look at how the court ruled on those two transactions. The court firstly raised a valid question. Is an interest in Bitcoin property? The word property itself is ambiguous, and Professor Gray used to say that the property doesn't really exist. It's a mere illusion. But in legal world, the established principles are that property is used to describe many different kinds of relationship between a person and a subject matter. And the word refers to a bundle of rights or a legally endorsed concentration of power over things and resources. In National Trustee Executors and Agency Company and Federal Commissioner of Taxation, Justice Kittle reasoning implies that all personal property must consist of 1. Choosing position, which normally refers to position over a tangible item, or choosing action, normally in relation to an intangible right such as a debt or a contractual claim. From that perspective, as concluded by Justice Jackman during his speech at Commercial Law Association, Bitcoin should consider as a truth in action. Before this case, however, no judge of a superior court in Australia has determined upon a trial of a proceeding that a person's interest in cryptocurrency, such as Bitcoin, is property. A number of judges in England, Wales, New Zealand, and Singapore had found that a person's interest in cryptocurrency is property. In UK, Justice Bryan in AA and Persons Unknown case could not conclude that cryptocurrency falls into any definition of choosing possession or choosing action, but it is still considered as property. The most convincing approach lies in the 4 criteria set out in the Lord Wilberforce classic definition of property in National Provincial Bank and Annieworth, as being, firstly, it must be definable. Secondly, it must be identifiable by third parties. Thirdly, it's capable in their nature of assumption by third parties. And fourthly, it has some degree of permanence. The Australian court in this case applied Lord Wilberforce's approach and concluded that Bitcoin meets all the criteria to be a property. The court made a few interesting observations. Firstly, the court stated that you cannot see the transfer parties' identities doesn't mean that those Bitcoins are not identifiable. The data allocated to one's public key will not be confused with another. Secondly, using private key is just like using a PIN. A person can prevent any involuntary transfers and deal with the coins to exclude any third parties. This reflects the person's control over it exclusively to others. Number 3, Bitcoin has very active trading markets throughout the world. So although a transfer of Bitcoin doesn't mean actual transfer of one's interest in the Bitcoin, it's accepted as a commercial transaction of proprietary interest. Number 4, Bitcoins are recorded on the shared public ledger, which represents the entire life of the crypto coin. That reflects a degree of permanence or stability. The Australian court made it clear that interest in Bitcoin is not just a mere interest in information or mere holding electronic data. It implies the power of undertaking transactions on a network. The Australian court even took a step further and announced that Bitcoin is an electronic coin. Following that logic, the court ruled that those 25 Bitcoins transferred to the accountant are considered as assets held in trust for the benefits of the company. The accountant had been in breach of her fiduciary duty by failing to return the sale proceeds to the company. The court ordered the accountant to repay the equivalent value of the Bitcoins at the time those Bitcoins were sold by her. The final relief granted, however, is a bit underwhelming because of 2 reasons. Firstly, at the time of the trial, the Bitcoin's price is about 100,000, being 10 times of the price when they made the initial contributions to the company. But the court did not reward the damages on the basis of the current price, but on the basis of the price at the transaction date. So even if the company or its liquidator could recover 25 Bitcoins from the accountant, the value was limited to about $168,000 rather than $2.5 million. Secondly, the company didn't get any relief associated with 36 Bitcoins delivered to the accountant, partly because they did not plead the case well. First of all, they relied on the argument of abatement, which was entirely rejected by the court. Secondly, they didn't fully prepare the pleadings against the accountant's husband or other parties who received benefits from those 36 Bitcoins, and they only briefly addressed them in the submissions. But in any event, this Australian court case still transformed Bitcoin from a digital curiosity into something with real legal protection. What's the conclusion? Well, the decision doesn't just affect Bitcoin. It opens the door for all kinds of digital assets to gain legal recognition. Think NFTs, USDT, and any digital property, all potentially covered by this precedent. Now, your crypto can be included in your will or held in trust, just like traditional assets. And during bankruptcy proceedings, your Bitcoin gets treated like any other valuable property and can be recovered by bankruptcy trustees. What's more, this Australian rulings comes at a time when the country is rethinking how it taxes crypto. The cases has opened the door for crypto to finally enter into the mainstream. This isn't just some technical legal detail. It fundamentally changes the relationship between you, your digital asset, and the legal system that protects them. So what's next? What specific laws will follow to further define and govern digital assets? How digital assets can be enforced and passed on to the next generation? We will discuss those topics in further videos. Thank you for watching. We'll see you next time.